right, everyone. So today's presentation I've titled Behind the Rules, How New York Makes the Law Work. Try to be creative here, want to keep you engaged. Can be a little dry. I'm going to do my best to avoid that dryness. Some of the recovering attorneys on the call might, they understand this process. Love any of your input. I know there's a lot of nuances and some exceptions to the rules I'm about to go through. And so if anyone has, experience or wants to, kind of expand on anything I say, please feel free because I love to collaborate with everyone's expertise and I think we can learn from each other. All right, so just a little bit about Riverkeeper. Rebecca, you could hit the next slide. Awesome. For those of you that don't know, Riverkeeper is an environmental nonprofit organization whose mission is to protect and restore the Hudson River from source to sea and safeguard drinking water supplies through advocacy rooted in community partnerships, science, and the law. So we're a membership-based organization, and we focus on the entire Hudson River watershed. All right, but let's get into this Oh, I'm sorry, disclaimer. Yeah. This presentation is just providing basic information on New York's rulemaking process. I am not giving you any legal advice. If you have specific questions, I recommend that you consult an attorney on those specific issues. Again, this is just providing an overview about the rulemaking process and not directly providing legal advice. So with that said, now we can jump into the good stuff. We're going to go over kind of what is the State Administrative Procedure Act. Then we're going to talk about the state's rulemaking process. We'll go through some of the other documents you might see when the agency issues a rulemaking proposal. And then the most important part, how can the public get involved? All right, so starting with the New York State Administrative Procedure Act. Let's do an overview. Yep, next slide, Rebecca. Thank you. So the rulemaking process is constructed around the fundamental belief that people in New York have a right to participate in the development of its law. Since administrative rules have the full force and effect of laws, New York and the federal government and nearly every other state and territory maintains a systematic approach to ensure that public comment during the proposal stage happens. And they want to make sure that this public input comes before any rule is finalized. This is really key for our participatory democracy. It is key that New York provides the public the opportunity to comment on the proposed rule. And I know I've just said that 3 times, but the key of this presentation is public involvement. That is the whole purpose that the Administrative Procedure Act exists. So the New York State Administrative Procedure Act, I'll just call it SAPA, sets out a formal process that every state agency must follow before its rule can become effective. And it establishes uniform procedures for state agencies to propose and issue regulations, conduct adjudicatory proceedings, issue licenses. And so the agency may adopt by rule additional procedures that are not inconsistent with the statute. So there might be other procedures that specific agencies follow that are not in SAPA. As long as it's not inconsistent, that's okay for them to move forward with their own procedural requirements. All right, let's get into some key terms. So highlighting some terms you might hear, let's start with statute. A statute is a formal written law enacted by the state legislature, and it's going to be signed into law by the governor. It's a type of legislative act, meaning it's a law created through this legislative process. And it's distinct from court decisions. You might hear references to, oh, that's case law. That's law made based on a specific case or judgment issued in a court ruling. And it's different than rules made by government agencies, which are the regulations. But I'm not here to talk about how a bill becomes a law. I can't do that little song. I'm here to focus on the regulatory process. Although I tried to see if there was a song, there's no song that says, I'm just an ordinary reg. Anyway, if you haven't watched How the Bill Becomes a Law, highly recommend. So regulations is an official rule issued by a regulatory agency that has the force of law. The phrase rules and regulations is often confusing, but those two phrases actually mean the same thing and they're used interchangeably. So you see the word regulations and you see the word rule, same thing. In New York, the term rule is often used more frequently, hence why the procedures followed are called the rulemaking process, not the regulation making process. Um, and so regulations are subordinate to statute. So it's statute, then it's the regulations. And these regulations can't be contrary to anything in the statutory provision, or they're going to be deemed invalid. You might also sometimes hear the word guidance. Agencies often issue their own guidance materials. These materials provide interpretations, clarifications, and recommendations, but they do not carry any legal weight. The legal requirements come from the statute itself and the regulations. The guidance is just to provide clarification. And finally, another term that comes up, and I think we're seeing a lot of this term, is executive orders. Now, the governor may issue an executive order to temporarily suspend specific provisions of any statute, local law, ordinance. You'll usually see executive orders issued during state disaster emergencies, and they're issued when compliance with provisions of the law would prevent or hinder or delay action necessary to cope with the disaster. So the governor may not use the powers in an open-ended manner, and there are some restrictions on what the governor may exercise the powers to accomplish. So we saw a lot of executive orders issued during COVID. So I think we're seeing a lot of executive orders issued now, but it's just another way to accomplish something. But again, we're focusing on regulation, so we can always go back and discuss those terms if necessary. Let's talk about rulemaking bodies. Yep. Yeah, thanks, Rebecca. So the state legislature and the governor are responsible for enacting laws in New York. And rulemaking powers are state agencies, and they derive their powers from those state laws. Agencies are empowered to develop rules and regulations, and they're responsible for adhering to any other applicable provision of law. Administrative agencies may not exercise, in the exercise of their rulemaking authority, promulgate regulations that do not comply with the plain meaning of statutory language. So they are only allowed to enact regulations that they're authorized to control. So DEC, for example, is allowed to adopt regulations for a wide range of environmental issues, including hazardous waste management, endangered species protection, activities in freshwater wetlands. Specifically, DEC is mandated by the Environmental Conservation Law, that's the statute, to adopt regulations that are at least as stringent as EPA's regulations with respect to hazardous waste. DEC's regulations are set forth in Title VI of the New York Code of Rules and Regulations. So that's just one example. And so I have agencies that I'm sure we're all very familiar with on this screen, but there are other rulemaking bodies besides just these departments. You could have authorities like the New York State Authority, the New York State Bridge Authority, the Power Authority of New York State. You can have commissions like the Waterfront Commission of New York Harbor, the Lake Champlain Bridge Commission. There are trusts that have authority to adopt rules and regulations. You have committees like the Committee on Open Government, boards like the State Mediation Board, and agencies like the Genesee County Industrial Development Agency. So there are other agencies out there that have the ability to adopt regulations that you might be less familiar with. So just keep that in mind. All right, now let's talk about the rulemaking process. So SAPA establishes a three-step process for all rulemaking activities. So to adopt a new rule or to amend or repeal an existing rule, you first have to issue a notice of proposed rulemaking, and that has to be published in the state register. Then the agency has to receive public comment on that proposed rulemaking. Once they close the public comment period, they have to file with the Department of State the final rule. And so the final rule will be adopted in the it will be published in the state register. Publication in the state register. I keep wanting to say legislative. Publication in the state register. Rebecca, you can go to the next slide. Fabulous. So, like I said, any proposed rulemaking has to be published in the state register. The state register provides public notice of the proposed rulemaking. It is issued every Wednesday. Now, the Department of State is responsible for producing the weekly New York State Register, which plays a central role in the rulemaking process. It's going to include the rulemaking notices. It'll notify you about any changes in the rulemaking, any public hearings, any extension of public comment periods. It's all going to be in the state register. Next slide, Rebecca. So my first recommendation is that everybody go and sign up for the state register if you're not already. So I put this slide on so you can see the website and go and just hit subscribe. You'll see on the left-hand side, it says get updates. Hit subscribe. That will get you on the listserv and you will get an email every Wednesday morning with the state register. Highly recommend. It gives you updates. It's really easy to kind of glance through and see if there's anything that interests you and helps you just stay up to date with what's going on in New York State. So, recommendation number one, there'll be other recommendations throughout this presentation. Sign up for the state register. Awesome. So let's get into the notice of proposed rulemaking. What is this? Prior to the adoption of a rule, an agency has to submit a notice of proposed rulemaking to the Secretary of State for publication in the state register and has to afford the public an opportunity to comment on that proposed rule. Publication of the notice initiates the public comment period. Now, unless a different time is specified by statute, the notice of proposed rulemaking must appear in the state register at least 60 days prior to either the addition, amendment, or repeal of a rule for which the statute does not require that a public hearing be held prior to adoption, or the first public hearing on the proposed rule for which such hearing is so required. When appropriate in the judgment of an agency, a notice may also be published in newspapers of general circulation, or they might be issued in trade industry or professional publications. That's in addition to the state register. It's not instead of. So you might see a proposed notice elsewhere. And usually the agency will issue a press release on the website that says, they've issued this proposed rulemaking. So in that proposed rulemaking, you're going to see a citation to the statutory authority. You'll get the full text of the rule or a summary if the text is going to be longer than 2,000 words. You'll get the time, date, and location of any public hearing and the name and address of the agency contact person to whom comments are going to be addressed. All right, public comment. So in some cases, public hearings will be held to provide opportunity to provide oral comments on a proposed rule, but you're definitely going to have an opportunity to submit written comments. Now, written and oral comments must be taken into consideration by an agency prior to adoption of a rule. And because it's important for citizens to have an opportunity to comment, the legislature has provided that agencies must accept comment for at least 60 days after the proposal is published in that state register. Now, agencies may elect to allow more than the minimum number of days for comment and to hold public hearings even if they're not required to do so. So the state agency has some discretion for the length of time of that public comment period and whether they're going to have public hearings and how many public hearings. One thing I can recommend is asking for more time if you think that the proposed rulemaking is complicated, lengthy, requires expertise. Agencies, again, like I said, they can extend the comment period. And so asking for more time could be beneficial. They could give you an extra 30 days, an extra 60 days in some cases. But just know that, just because it's issued with a 60-day public comment period, that's not necessarily set in stone, and there is opportunity to have an extension on that. It is within the agency's discretion to grant that extension request, but they'll never consider it if they're never asked. So recommendation number two, don't be afraid to ask for extra time if you think it'll help you write your comments and get information out there. All right, notice of adoption. So after publication in the state register and receipt of public comment, an agency may either adopt, revise, or withdraw their proposal. If adopted, the agency must file the full text of the rule with the Department of State. And at the same time, a notice of adoption is submitted for publication in the state register. And this will indicate that the proposal has been adopted and will include the date that that regulation is effective. The notice of adoption must include the assessment of public comment, and if such assessment exceeds 2,000 words, the notice shall include only a summary of such assessment, and that assessment will be posted elsewhere on the agency's website. So you will get a response. Now, DEC, any agency, do the most work recently with DEC, but any agency, when they're providing that assessment of public comment, they can group the public comments together. So you might not receive an individual response from the agency to your specific comment. It might be lumped in with other comments of the same type. So just know that is deemed acceptable. All right. Substantial revisions. A substantial revision is any addition, deletion, or other change in the text of a rule proposed for adoption which materially alters its purpose, meaning, or effect. These do not include revisions that are going to merely define or clarify the text. They have to be, again, meet that substantial definition. SAPA requires that a notice of revised rulemaking be filed where changes are deemed substantial. And once that notice is filed, that notice of revised rulemaking, it's going to launch an additional 45-day public comment period so that the public has an opportunity to comment on revisions. If a proposal is withdrawn, the agency cannot adopt that same or similar proposal without filing a new notice of proposed rulemaking and providing the public with a new minimum 60-day public comment period. So the notice of revised rulemaking triggers 45 days, and then the notice of any withdrawal, again, will have to require a notice of proposed rulemaking, and they still have to start from the beginning all over again. Now, the exception to this process is an emergency rulemaking. If an agency finds that the immediate adoption of a rule is necessary for the preservation of public health, safety, or general welfare, and that compliance with the requirements of SAPA would be contrary to the public interest, then the agency can dispense with all of those requirements and adopt the rule on an emergency basis. Now, this emergency rule cannot remain in effect for longer than 90 days after it's filed with the Secretary of State. There is an opportunity to get an extension if necessary, but it can't remain longer than 60 days after that. An example of an emergency rulemaking in New York was one that during COVID, the COVID-19 pandemic involved the New York State Department of Financial Services amending insurance laws to require health insurers to cover telehealth services from in-network providers. Even if the services would have been covered in an in-network provider's office, this was like a special rulemaking that was done just because COVID was happening. More recently, the DEC adopted an emergency rulemaking for new recreational regulations for Atlantic striped bass to remain in compliance with the Atlantic States Marine Fisheries Commission. So they issued this emergency rulemaking that's only going to be effective for 90 days. If you go to DEC's page about proposed rulemakings, you will see if you scroll down past all the proposed rulemakings, there's a category, emergency rulemaking, and it's right there. You can see which ones have been deemed emergency. All right, supporting documentation. So when the final rule gets adopted or it's, the proposed rulemaking's out there, you're going to see other documents in connection with that. You'll see your express terms. Okay, that's going to say what the proposed rulemaking does. But before that, One thing in this process that is not mandatory, it's a non-binding step that some state agencies can take, and I think it's becoming more and more popular, is an advance notice of proposed rulemaking. And so this advance notice is going to be filed before the notice of proposed rulemaking, and its primary purpose is to gather information from the public on specific questions that will help the agency develop that proposed rulemaking. So most recently, we saw an advanced notice of proposed rulemaking for DEC's wetland regulations, where they issued the ANPRM with specific questions that they wanted public input on because they needed guidance on how they were going to finalize the draft proposed rulemaking. And so I think this is becoming more and more popular. Um, these documents themselves do not have any regulatory impact, and they're simply a way to solicit public comment. And then future rulemakings will be based on all those public comments that they gather. So I think it is helpful, and it's just another opportunity to, voice your concerns and get your inputs out there. So now advance notice went out. They have the draft proposed rulemakings out there. You're also going to see, besides the express terms, like I mentioned, other documents like the regulatory impact statement. Now, this document's required to assess the potential impacts of the proposed regulation. And it's going to analyze the benefits and costs of the regulation and consider alternatives and identify potential impacts on various stakeholders. And it helps the decision makers understand the consequences of their regulatory choices. So this is required. Every rulemaking will have a regulatory impact statement. All right, next slide. We also might see regulatory flexibility for small businesses and local governments. Now, this document is analyzes the potential impact of a proposed rule on small businesses or local governments. And it's going to assess whether the rule will have a significant economic impact on a substantial number of small entities, and if so, considers ways to minimize the adverse impact. Now, not every rulemaking might have impacts to small businesses or local governments, so the proposed rule might not come with this document, but many do. Another type of document that we might see is the rural area flexibility analysis. And this is going to review, it's required when rural areas in the state are going to be impacted by the rule. And again, does an assessment of how those rural areas will be impacted and establishes ways to minimize those impacts. And then we have the job impact statement. Now, this is required if the regulation will have substantial adverse impacts on jobs or employment opportunities. And this is meant to just consider what kind of impacts might be there, what kind of impact you might have on jobs, employments. It's going to look at opportunities for self-employment. It's going to look at impacts to part-time or seasonal employment and kind of go through that. This document is required to assess the nature of the impact. It's going to look at the categories of the jobs, approximate number of jobs that are going to be affected in each category. It looks at region-specific impacts. And it's going to, again, like the other documents, assess measures in which the agency has taken or could take to minimize those unnecessary adverse impacts on existing jobs, with the whole goal to promote the development of new employment opportunities and reduce impacts to existing jobs. All right, so this is the most important part of the presentation, public engagement. You let your voice be heard. You can change policy, which is going to change industry. Next slide, Rebecca. Your voice matters. The way to get your voice heard is going to be writing comments, speaking at public hearings, attending information sessions, finding organizations that may be prepared an action alert and submitting an action alert. There's never too much. If you submit a written comment, it doesn't mean, hey, I'm not going to speak at a public hearing. You should do it all, as much as you can, to make your voice heard. It is so, so critical. And this is like my third key recommendation, get involved and write your comments. The advice I can give that, I think people are hesitant sometimes to submit public comments on these regulations that are issued. They can be very technical, and I think some members of the general public might not feel comfortable commenting on a technical document. It doesn't matter whether you're a lawyer, a scientist, or some other technical expert on the matter, your voice does matter, and you can simply pull on your own experiences about why you feel a certain way and why you want the agency to consider certain impacts or act a certain way. Pulling on your own experience can be just as valuable as pulling out the legal jargon or, the scientific jargon. So just because you might be an average person, or have a different set of skills or expertise, your voice, I've said it like 5 times on this slide. I just can't emphasize it enough that submitting comments and getting involved is for everyone. All right. I think I made that clear. I think we can go to was practically my last slide, judicial review. At the end of the day, the agency issues its final regulation, and you might not be happy with it. It's not the end of the road. There is judicial review, and you can challenge that regulation under the Article 78 process. Now, there is a short statute of limitations, meaning the time for which you have to start file your complaint is 4 months after the determination becomes final. So just know that this is not an endless time frame. If you are unhappy with the regulation and you believe that the agency didn't comply with SAPA, you can move forward with an Article 78 challenge. Now, grounds for challenging, you might say that the agency lacked the authority to create the rule, the agency did not follow the proper procedures, that there was insufficient evidence or a lack of reasonable basis to support the rule. Maybe the agency didn't issue one of those other documents that we talked about where they should have. Things like that will be subject to review. And so that's important to kind of keep in mind so that you know all your options going forward.